Before we begin, a quick and important disclaimer. This video is for educational and entertainment purposes only and does not constitute legal, financial, or tax advice. Divorce laws and retirement regulations, specifically those governing 401k accounts and ERISA qualified plans, are subject to complex federal and state jurisdictions which have evolved significantly since the 2010s. The historical trends and case studies discussed here may not apply to your specific situation. Always consult with a qualified family law attorney and a certified financial planner or tax professional to conduct your own due diligence before making decisions regarding marital property and asset division. Imagine spending 25 years meticulously building a fortress. You skipped the luxury vacations, you maximized your employer match every single month, and you watched your 401k balance climb from a few $1,000s to a seven-figure nest egg. You thought you were building a private island for your retirement. But then, a single legal document lands on your kitchen table, and suddenly that fortress isn't just yours anymore. In the eyes of the law during the 2010s, that 401k wasn't just a bank account, it was a communal pot of gold that was about to be sliced down the middle with surgical, and sometimes brutal, precision. In the 2010s, the United States witnessed a massive shift in how wealth was liquidated during a split, particularly as the gray divorce trend exploded among baby boomers. We are talking about billions of dollars in retirement liquidity changing hands in a decade defined by the recovery from the 2008 financial crisis. If you don't understand the mechanics of the Qualified Domestic Relations Order, or the QDRO, you aren't just losing half your money. You are potentially losing your entire financial future to taxes, penalties, and administrative errors that haunt you for decades. Today, we are performing a deep dive autopsy on the 401k divorce era of the 2010s to show you exactly how wealth was protected, how it was lost, and the high-stakes chess game played in family courts across America. To understand why the 2010s were so unique, we have to look at the economic backdrop. Coming out of the Great Recession, the 401k had officially supplanted the traditional pension as the primary vehicle for American retirement. Unlike a pension which promises a monthly check, a 401k is a defined contribution plan. It is a live, fluctuating pile of cash and securities. When a couple in 2015 decided to call it quits, the 401k was often their largest liquid asset, sometimes even eclipsing the equity in their primary residence. Let's look at a historical case study to illustrate the gravity of this. Consider a hypothetical couple in Illinois. Let's call them Robert and Sarah. Filing for divorce in 2014. Robert had worked at a manufacturing firm for 30 years. His 401k was valued at $800,000. In their minds, they could just agree to split it $400,000 each. But the IRS and the Department of Labor have very different ideas. If Robert simply cut Sarah a check for $400,000 from that account, the IRS would have viewed it as a premature distribution. Robert would have been hit with an immediate 10% early withdrawal penalty if he was under age 59 and a half, plus federal and state income taxes that could have eaten 30% to 40% of the total. That $400,000 fair split would have evaporated into $240,000 before Sarah even saw it. This is where the 2010s legal landscape became incredibly technical. The only way to move that money without triggering a tax catastrophe was through a QDRO. This is a legal order, usually prepared by a specialist rather than a general divorce attorney, that recognizes the existence of an alternate payee's right to receive all or a portion of the benefits payable under a retirement plan. During the mid-2010s, the complexity of these orders led to a rise in QDRO mills, specialized legal firms that did nothing but draft these documents because the margin for error was zero. A major point of contention during this era was the determination of marital versus separate property. This is a detail that many people overlook until they are in the heat of a deposition. Suppose you started your 401k 5 years before you got married. In many states during the 2010s, those first 5 years of contributions, and the subsequent growth on those specific contributions, were considered separate property. However, calculating the exact value of that growth over a 20-year marriage required forensic accounting. You had to track the performance of specific mutual funds or stocks within the 401k from the date of the wedding to the date of the separation. If the record keeper for your 401k changed 3 times in 20 years, which was common as companies merged in the 2010s, finding those historical statements became a nightmare. The potential outcomes for those who didn't have their paperwork in order were often devastating. We saw cases where individuals lost a significant portion of their separate property simply because they couldn't prove the baseline balance from 15 years prior. This taught the American public a hard lesson. Your 401k isn't just an investment account. It's a legal entity governed by ERISA, the Employee Retirement Income Security Act of 1974. Furthermore, the 2010s introduced the valuation date trap. Between 2010 and 2019, the S&P 500 was in one of the longest bull markets in history. If a divorce was filed in January when the market was high, but the QDRO wasn't finalized until October during a market dip, who bears the loss? Or conversely, who gets the gain? In a volatile market, a delay of 3 months in the legal system could mean a difference of tens of thousands of dollars in the final transfer. Skilled attorneys began insisting on language that specified whether the alternate payee was entitled to a flat dollar amount or a percentage of the account adjusted for investment earnings and losses. This decade also saw the rise of the offset strategy. Because 401k money is pre-tax, meaning you owe taxes when you take it out, and house equity is often post-tax, meaning you've already paid taxes on the income used to pay the mortgage, they are not equal dollars. A $500,000 401k is not worth the same as a $500,000 house. In the 2010s, sophisticated financial neutrals began teaching couples how to tax adjust these assets. If you took the 401k and your spouse took the house, you were essentially taking a 20% to 30% haircut on the actual purchasing power of your asset. As we move through this deep dive, we are going to break down the specific steps used by high net worth individuals during this period to ring-fence their assets. We will look at how the 2017 Tax Cuts and Jobs Act altered the math for alimony and how that indirectly pressured 401k negotiations. We will examine the specific language required in a QDRO to ensure you aren't paying your ex-spouse's share of the taxes. The 2010s were a masterclass in the intersection of family law and federal retirement policy. It was a time when standard divorce settlements were replaced by highly technical financial engineering. Whether you are looking back to understand a past settlement or looking forward to protecting your own future, understanding the 401k divorce mechanics of this era is essential. The goal isn't just to divide the pie. It's to make sure the IRS doesn't take the biggest slice before either of you gets a bite. We are going to examine the role of the plan administrator, the pitfalls of 401k loans during a divorce, and why beneficiary designations became the most dangerous loose end in American law. Stay with us as we dismantle the complexities of the 401k deep dive. To understand why beneficiary designations became a legal minefield in the 2010s, we have to look at the supreme authority of federal law over state law. Imagine a scenario involving a man named Michael in 2012. Michael had been divorced from his first wife, Jennifer, for 5 years. His divorce decree, signed by a state judge, explicitly stated that Jennifer waived all rights to his retirement accounts. Michael eventually remarried a woman named Linda. When Michael unexpectedly passed away in 2014, Linda went to claim the 401k, assuming she was the rightful heir. However, Michael had never updated the beneficiary form with his HR department. Jennifer's name was still on the paper. In a series of landmark historical trends during this era, the Supreme Court and federal appellate courts reaffirmed a brutal reality. ERISA, the federal law governing 401ks, almost always trumps state divorce decrees. Even though a state judge said Jennifer had no right to the money, the plan administrator was legally obligated to pay the person listed on the plan documents. Linda was left with nothing but a pile of legal fees. This specific oversight became one of the most common ways wealth was accidentally transferred to ex-spouses in the 2010s. It serves as a stark reminder that in the world of federal retirement assets, the paperwork you signed at your orientation 20 years ago often carries more weight than a signed divorce settlement. Now let's pivot to one of the most misunderstood and dangerous components of the 401k divorce: the outstanding 401k loan. During the mid-2010s, many Americans used their 401ks as personal banks, taking out loans for home renovations or debt consolidation. If you were in the middle of a divorce in 2016 and you had a $20,000 loan balance against your 401k, that debt didn't just disappear. It became a radioactive asset in the negotiation. Consider a case study involving a couple named David and Susan. David had a 401k worth $200,000, but he had taken a $40,000 loan against it to pay for his daughter's wedding. On paper, the account looks like it is worth $200,000. But in reality, $40,000 of that is actually a debt David owes back to himself. If the court orders a 50-50 split, does Susan get $100,000? Or does she get $80,000 plus half of a $40,000 debt? If the plan was divided and David was forced to leave his job or could not repay the loan during the divorce process, that $40,000 would be treated as a deemed distribution. This meant David would owe income taxes on that $40,000, plus a 10% early withdrawal penalty if he was under 59 and a half. In the 2010s, many unsuspecting spouses walked away from a divorce thinking they had settled their debts, only to receive a 1099-R tax form the following January that triggered a massive unplanned tax bill. This created a secondary wave of financial trauma long after the divorce papers were filed. The complexity deepens when we look at the role of the plan administrator. In the 2010s, the plan administrator acted as the ultimate gatekeeper. Even if two spouses and a judge agreed on how to split a 401k, the plan administrator could reject the QDRO if the language didn't perfectly match the plan's specific summary plan description. If a lawyer drafted a QDRO saying the ex-spouse should receive a certain type of survivor benefit that the plan didn't actually offer, the order was dead on arrival. This often resulted in months of back-and-forth legal work, with billable hours draining the very assets the couple was fighting over. Imagine if a couple named Mark and Elena were divorcing in 2018. They spent $10,000 in legal fees to draft a perfect 50-page settlement. They submitted it to Mark's employer, a Fortune 500 company. 6 weeks later, a clerk in the benefits department sent it back with a one-sentence rejection because the document used the term total account balance instead of the plan-approved term vested account balance. Because Mark had only been at the company for 4 years and wasn't fully vested, the distinction was worth $30,000. The entire legal process had to start over. This was the granular reality of 401k litigation in the 2010s. We also have to discuss the 2010s phenomenon of the missing data. As mentioned earlier, the 2010s were a period of massive corporate consolidation. If you worked for a company that was bought by another firm, your 401k was often migrated to a new platform. If you were trying to prove in a 2015 divorce that $50,000 of your 401k was separate property from 1998, you had to find the historical records. But in many cases, those records were lost in digital migrations or destroyed by plan providers after a 7-year retention period. Without that evidence, the court would often default to the assumption that the entire account was marital property. This created a situation where the most organized spouse, the one who kept shoeboxes of paper statements from the late 90s, often walked away with significantly more wealth. Step by step, the process of dividing these assets required a surgical approach that most people were unprepared for. First, you had to obtain the actual summary plan description from the employer. Second, you had to determine the exact valuation date, which could be the date of filing, the date of the divorce decree, or a mutually agreed upon date. Third, you had to calculate the gains and losses on the awarded amount between the valuation date and the actual date of transfer. If the S&P 500 jumped 5% during that 3-month administrative window, that 5% growth on the ex-spouse share belonged to them. If the lawyer forgot to include language about earnings and losses, the owner of the account might end up keeping the growth on money that wasn't even theirs anymore, leading to more litigation. The 2010s also saw a rise in the use of defined contribution plans as a tool for alimony. In some historical trends, instead of paying $2,000 a month in cash for alimony, a spouse might agree to give up a larger percentage of the 401k. This was often seen as a win-win. The payer didn't have to worry about monthly cash flow, and the receiver got a lump sum for their future. But this was a trap for the unwary. Money in a 401k is not the same as money in a checking account. You cannot pay your mortgage with a 401k balance without triggering taxes and penalties. In 2026, looking back at these cases, we see that many people who took the 401k instead of cash alimony ended up house poor, sitting on $1 million retirement account they couldn't touch for 15 years while struggling to pay their monthly utility bills. This era of financial history proves that the 401k was never just a simple savings account. It was a complex legal instrument that required a deep understanding of tax codes, federal labor laws, and investment mathematics. But what happened when the stakes were even higher? What happened when the 401k wasn't just a few $100,000, but involved executive compensation packages, restricted stock units, and non-qualified deferred compensation plans? As we move into the next part of this masterclass, we are going to look at the shadow world of executive 401ks and the secret tactics used to valuation shop during a market swing. We will explore the hidden fees that plan administrators charged for processing QDROs, which could sometimes reach into the thousands of dollars, and the shocking reason why some people chose to purposely trigger a tax penalty just to get their money out faster. The 2010s was a decade of financial warfare in the courtroom, and we are just getting started. If you think a 401k split is just a simple math problem, wait until you see what happens when the IRS finds a mistake in your QDRO 5 years after the divorce is final. To understand the absolute carnage that a defective QDRO can cause half a decade later, we have to look at the internal accounting mechanisms of the IRS during the 2010s. Imagine a woman named Karen who finalized her divorce in 2013. She was awarded $300,000 from her ex-husband's 401k. The QDRO was drafted, signed by a judge, and accepted by the plan administrator. Karen rolled that money into her own traditional IRA and went about her life. Fast forward to 2018. The IRS conducts a routine audit or a document matching program flagging the original transfer. They discover that the QDRO was missing a specific federal tax identification number, or used a formula for calculating the pre-tax basis that violated a technicality in the tax code. Suddenly, that $300,000 transfer is reclassified. It is no longer a tax-free rollover. It is viewed as a prohibited distribution to the husband followed by a taxable gift to Karen. The potential outcomes here are a total financial nightmare. The husband is hit with back taxes and penalties for a distribution he never actually kept, and Karen is told her IRA contribution was over the limit for the last 5 years, triggering a 6% excise tax for every single year that money sat in her account. This isn't a hypothetical ghost story. These were the administrative landmines of the 2010s that forensic accountants are still cleaning up in 2026. This brings us to the high-stakes world of executive compensation and the 401k shadow accounts. In the 2010s, high earners often had more than just a standard 401k. They had supplemental executive retirement plans, or SERPs, and non-qualified deferred compensation plans. These are often referred to as top hat plans. During a 2015 divorce, these were the ultimate prize and the ultimate headache. Unlike a standard 401k, a SERP is often an unfunded liability of the company. It is essentially a contract that says the company will pay the executive later. Because these plans are non-qualified, they are not governed by the same ERISA rules that allow for a QDRO. You cannot simply use a QDRO to split a SERP. This led to the creation of the if, as, and when strategy in 2010's family courts. Imagine a tech executive in California named Jason. He has a 401k worth $500,000 and a non-qualified deferred comp plan worth $2 million that he can't touch until he retires or leaves the company. His spouse, Maria, wants half. Since the plan administrator won't recognize a QDRO, the court had to issue a SOAP, a certified order of assignment of proceeds, or a similar constructive trust. Jason was essentially ordered to pay Maria her share if, as, and when he received the money in the future. The historical trends of this era show that these future pay arrangements were incredibly risky. If the company went bankrupt in 2017, Jason's non-qualified plan could vanish because he is just an unsecured creditor of the company. Maria, who traded the family home for a share of that future $2 million, would be left with nothing. This is why the valuation of these plans during the 2010s often involved a deep discount for risk, sometimes as high as 40%, to account for the possibility that the money might never actually exist. Another layer of the 401k deep dive involves the hidden administrative costs of the 2010s. Many people didn't realize that plan administrators like Fidelity, Vanguard, or Schwab often charged a fee to review and process a QDRO. In the mid-2010s, these fees started to climb. It wasn't uncommon for a plan to charge $500 to $1,500 just to read the legal document your lawyer spent $3,000 drafting. If the document was rejected and had to be resubmitted, the fee might be charged again. In 2016, a landmark case study involved a couple who saw their 401k balance drop by several $1,000s purely due to administrative processing fees because their lawyers couldn't get the language right after 4 attempts. Then there is the issue of the 401k loan that was taken out during the marriage to pay for marital expenses. Let's look at a scenario involving a couple named Brian and Sarah in 2014. Brian took a $50,000 loan from his 401k to consolidate the couple's credit card debt. When they divorced, Brian argued that the 401k should be valued at its net amount, the cash in the account minus the loan. Sarah argued the loan was a marital debt used to pay for their shared lifestyle, and that Brian should be responsible for paying it back, while she still gets half of the gross value. In the 2010s, courts often took a split approach. If the loan was used for a marital purpose like a new roof or medical bills, the debt was often shared. But the logistics were impossible. You can't force an ex-spouse to make monthly payments into your 401k account. The solution was usually an offset. Brian would keep the loan but would receive $50,000 more of another asset like a brokerage account or a car to balance it out. However, this didn't solve the tax risk. If Brian lost his job in 2015, the loan would be treated as a distribution, and he would be the only one paying the tax and penalty on a debt that was used for the benefit of both spouses. As the decade progressed, we also saw the weaponization of investment allocations within the 401k during the pendency of a divorce. Imagine it is 2011. The market is recovering but remains volatile. Mark knows his wife Jessica is going to get 50% of his 401k. To be spiteful or perhaps out of an aggressive attempt to recover lost wealth, Mark moves the entire 401k allocation into a high-risk emerging markets fund or a single volatile stock. If the account drops 20% before the QDRO is finalized, Jessica's share is 20% smaller. During this era, savvy attorneys began requesting freeze orders or injunctions at the moment of filing. These orders prevented the account holder from changing investment allocations without the consent of the other spouse or a court order. This was the beginning of what we now call fiduciary divorce management. It forced the account holder to act as a steward for the marital estate, even if they were sleeping on their brother's couch and hated their spouse. If Mark moved the money into a risky asset and it crashed, the court in 2012 or 2013 might hold him personally liable for the waste of marital assets and order him to make Jessica whole from his share of other property. The sheer volume of paperwork required in the 2010s for a 401k split was staggering. You needed the plan joinder, the QDRO, the written acknowledgement from the plan administrator, and the 1099-R tracking for the following year. Every step was a chance for a typo to ruin a life. We even saw instances where a spouse died after the divorce was final but before the QDRO was served to the plan administrator. In many states in the 2010s, if that happened, the surviving ex-spouse might still be legally entitled to the money as the beneficiary, or conversely, might be completely locked out of the money they were awarded because the legal process wasn't finished. The 2010s taught us that the 401k is a living, breathing legal entity. It isn't a static number on a screen. It is a collection of rights, obligations, and tax liabilities. But what happens when the 401k is not at a traditional company? What happens when you are dealing with a 403b from a hospital, a 457 plan from a government entity, or the thrift savings plan for military members? Each of these has its own set of rules, its own specific forms, and its own unique traps. In the next part of this deep dive, we are going to explore the unique world of the TSP and the 403b, including why a teacher's retirement is often harder to split than a CEO's. We will look at the 2010 shift toward the separate interest versus shared interest QDRO, and why choosing the wrong one could mean you lose your retirement income the moment your ex-spouse passes away. The stakes are getting higher and the rules are getting weirder. If you think you've seen the worst of 401k litigation, you haven't seen what happens when the government is your plan administrator. The Thrift Savings Plan, or TSP, is essentially the federal government's version of a 401k, but during the 2010s, it operated under a set of rules so rigid, they could make a standard corporate administrator look flexible. If you were a member of the military or a civil service employee divorcing in 2014, you weren't just dealing with a Risolite, you were dealing with the Federal Retirement Thrift Investment Board. They don't use the term QDRO. They use a Retirement Benefits Court Order, or RBCO. This distinction is not just semantic. If your lawyer submitted a standard 401k QDRO to the TSP board in 2015, it would be rejected immediately. Imagine a case study involving a captain in the Army named Christopher and his spouse, Amanda. They were divorcing in 2012 after 12 years of marriage. Christopher had a TSP balance of $150,000. In a corporate 401k, Amanda might have been able to roll her share into her own IRA and manage it however she liked. But the TSP in the 2010s had very specific requirements about how the money was moved. If the court order didn't explicitly state that the payment should be made directly to an IRA or an eligible employer plan, the TSP would simply cut Amanda a check. To the uninitiated, a check sounds great. But in reality, that check was a taxable event. The TSP would withhold 20% for federal taxes immediately. Amanda would have received $60,000 instead of the $75,000 she was awarded, and she would still owe the remaining tax balance and potential penalties at the end of the year. The 2010s also highlighted a massive disparity in how 403b plans, common in hospitals and public schools, were handled. Many 403(b) plans during this decade were invested in individual annuity contracts rather than mutual funds. This created a logistical nightmare for division. If a nurse named Deborah was divorcing her husband, Kevin, in 2016, and her 403(b) was housed in an older TRF annuity, the plan might not actually allow for the account to be split into two separate accounts. Instead, the plan might only allow for Kevin to receive a portion of the payments once Deborah actually retired and started drawing from the annuity. This is what we call a shared interest order. Kevin would be tethered to Deborah's retirement timeline. If Deborah decided to work until she was 75, Kevin wouldn't see a dime of that marital property until 2035, even if they divorced in 2016. This brings us to the critical choice of the 2010s. Separate interest versus shared interest. This is perhaps the most important technical decision in a retirement deep dive. In a separate interest order, the alternate payee's share is carved out into their own account. They can choose their own investments, name their own beneficiaries, and often start taking distributions as soon as the participant reaches the earliest retirement age allowed under the plan. In the 2010s, this was the gold standard for anyone who wanted a clean break. However, if you were dealing with a defined benefit component or an inflexible 403(b), you were often stuck with a shared interest order. In this historical trend, the alternate payee only gets paid when the participant gets paid. Imagine if Kevin, from our previous example, was granted a shared interest in Deborah's retirement. If Deborah died a year after retirement, and there were no survivor benefits specifically outlined in the QDRO, Kevin's checks would simply stop. He would lose his entire marital share because his interest was tied to Deborah's life. In the 2010s, many ex-spouses found themselves suddenly destitute when their former partner passed away because their lawyer didn't understand the necessity of a qualified pre-retirement survivor annuity, or QPSA, designation within the court order. Step by step, the 2010s taught us that the order of operations matters. If you were a teacher with a 403(b), the first step was a plan joinder. This was a legal move to join the retirement plan as a party to the divorce action. This effectively froze the account, preventing the participant from taking out a hardship withdrawal or changing the beneficiary, while the lawyers argued. Without a joinder, a disgruntled spouse could theoretically drain the account through a loan or a withdrawal before the judge could sign the final decree. In 2017, case studies began to emerge of participants who took massive distributions during the divorce process, spent the money, and left their spouses with a judgment for money that no longer existed. The data from the mid-2010s shows a significant rise in the cost of forensic accounting for these government and non-profit plans. Because the TSP and 403(b) plans often had different vesting schedules and contribution limits, determining the marital portion required a specialist. If a federal employee had 20 years of service but was only married for 10 of those years, how do you calculate the growth? Do you use the coverture fraction? In the 2010s, the coverture fraction became the standard mathematical formula. You take the number of months of marriage while in the plan and divide it by the total number of months of employment. If you were married for 120 months out of 240 months of service, the marital share is 50% of the total value. But here is the catch. Do you apply that 50% to the final balance? Or do you try to calculate the specific growth of the contributions made during those 120 months? Historical trends show that courts favored the simpler fraction, but this often led to unfair potential outcomes. If the market boomed during the first 10 years of service before the marriage, and stayed flat during the marriage, the spouse might be awarded a percentage of wealth they didn't actually help build. Conversely, if the market skyrocketed after the separation but before the divorce was final, the participant might be forced to share gains that occurred while they were living apart. This was the era where the date of separation became a $1 million data point. In 2026, we look back at the 2010s as the decade where the Qualified Domestic Relations Order became a specialized subfield of law. It was no longer enough for a divorce lawyer to be good at custody or alimony. They had to be an amateur actuary. The sheer variety of plans, 401k, 403(b), 457 TSP, KEO meant that a one-size-fits-all approach was a recipe for malpractice. We saw cases where a 457 plan, which is common for firefighters and police officers, allowed for distributions at any age upon separation from service without the 10% penalty. If a lawyer didn't know this, they might advise their client to take money from a 401k with a penalty, instead of the 457 without a penalty, costing them thousands in unnecessary taxes. But as complicated as these government and non-profit plans were, they still followed some form of logic. Things got truly chaotic when we entered the realm of small business 401ks and owner-only plans. In these scenarios, the participant was often the plan administrator. They held the keys to the kingdom. They were the ones responsible for approving their own ex-spouse QDRO. In the next part of this deep dive, we are going into the world of the self-employed 401k and the small business owner. We will explore how valuation manipulation became a common tactic in 2010's divorces and the specific way small business owners used planned terminations to try and outmaneuver their spouses. We will also look at the role of the 401k as a source of emergency funding for legal fees, and why that almost always backfired. The game of hide and seek with retirement assets is about to get very personal. If you think a big corporation is hard to deal with, wait until your ex-spouse is the one who has to sign off on your check. When the person you are divorcing is also the person who manages your retirement plan, the standard rules of engagement evaporate. In the 2010s, the rise of the solo 401k and small business retirement plans created a unique theater of conflict. Imagine a business owner named Thomas who ran a successful regional construction firm in Ohio. Thomas was the owner, the CEO, and crucially, the plan administrator for the company's 401k. His spouse, Emily, had spent 15 years supporting the business behind the scenes. When they filed for divorce in 2015, Thomas's 401k was valued at $1.2 million. In a traditional corporate setting, Emily's attorney would serve a QDRO to a faceless HR department. But in Thomas's case, the QDRO was served to Thomas himself. This created a massive conflict of interest that defined many high-stakes divorces in the mid-2010s. Thomas had the power to delay the approval of the QDRO indefinitely by claiming the document didn't meet the plan's specific requirements. He could argue that the plan didn't allow for lump sum distributions, or that the forensic accounting was flawed. Because he controlled the books, he could theoretically manipulate the reported value of the plan assets by changing the valuation dates, or by shifting investments into illiquid assets that were difficult to appraise. Historical trends from this era show that small business owners often use the plan termination strategy as a defensive maneuver. Imagine if Thomas, seeing the writing on the wall in 2016, decided to terminate the company 401k entirely before the divorce was finalized. By terminating the plan, he could force a distribution of all assets. While this would trigger taxes, it could also muddy the waters regarding Emily's claim to the growth of those assets. It was a scorched earth policy designed to reduce the liquid pool available for division. Emily's legal team would then have to scramble to prove that the termination was a bad faith effort to dissipate marital assets, a process that could take years and tens of thousands of dollars in expert witness fees. The 2010s also saw the peak of valuation manipulation through the use of alternative investments within self-directed 401ks. Unlike a standard 401k that holds publicly traded mutual funds, a self-directed 401k in 2014 could hold real estate, private equity, or even physical gold. If Thomas's 401k held a piece of commercial real estate, who decides what that land is worth? Thomas might produce an appraisal from 2011, during the tail end of the housing slump, claiming the property was worth $400,000. Emily would have to hire her own appraiser in 2015 to prove it was now worth $700,000. This battle of the experts was a hallmark of the 2010s, where the actual balance on a statement was merely the starting point for a long negotiation. Step by step, the process for Emily to protect herself required an aggressive legal posture. First, her team had to file a motion for a preliminary injunction to prevent Thomas from making any changes to the plan's investment structure or beneficiary designations. Second, they had to demand a full audit of the plan's administration records, not just the account statements. They needed to see if Thomas had taken out any secret loans or if he had shifted company profits into the 401k just before the separation to hide cash from the marital estate. In the 2010s, this was known as asset loading, where a business owner would maximize their 401k contributions to the legal limit, including profit-sharing components, right as the marriage was failing, effectively locking that cash into a vehicle that was harder for a spouse to touch immediately. Case studies from 2017 reveal another dangerous tactic: the 401k loan offset. A business owner might take a maximum $50,000 loan from their 401k to pay for business expenses or legal fees. When the divorce court looks at the assets, the owner argues that the 401k value is now $50,000 lower. If the spouse doesn't realize that the loan is essentially a debt the owner owes to themselves, they might accept a lower settlement. In 2026, we see the long-term fallout of these moves. where ex-spouses realized too late that they had been maneuvered into accepting values that were artificially deflated. The administrative burden on small plans during the 2010s was also used as a weapon. Thomas could claim that the company couldn't afford the $2,000 fee for an outside actuary to review the QDRO. Or he could simply ignore the legal correspondence altogether. This forced Emily to go back to the divorce judge to request a contempt of court order, adding layers of stress and cost. The lesson from this era was clear. When the spouse is the administrator, the QDRO is not just a form. It is a battle for transparency. Furthermore, we must address the 401k as a source of emergency funding for the divorce itself. In the mid-2010s, many people who lacked liquid cash tried to use their 401k to pay their divorce lawyers. This was a catastrophic financial move. To get $30,000 out to pay a retainer, an individual under 59.5 would have to withdraw roughly $45,000 to cover the 10% penalty and the 25% to 30% in combined state and federal taxes. Historical trends show that those who rated their 401ks during the litigation process often ended up with a significantly lower net worth at the end of the day than those who found other ways to finance their legal fees. The 2010s was a decade where the IRS became increasingly proficient at tracking these distributions. If you took a hardship withdrawal to pay for your divorce, the IRS could later challenge whether a legal fee actually met the strict definition of a hardship. If they disqualified the withdrawal, you could be hit with even more penalties and interest years down the line. This created a situation where people were literally burning their future retirement to pay for their present legal battle, a trade-off that rarely worked out in their favor. As we look deeper into the mechanics of these splits, we have to talk about the accidental distributions. In the 2010s, many plan administrators would automatically liquidate an account once a QDRO was approved if the balance was below a certain threshold, such as $5,000. If the spouse wasn't prepared to immediately roll that money into an IRA, the administrator would send them a check, withhold taxes, and effectively end their retirement savings for that portion of the asset. This forced liquidation was a common trap for lower balance accounts and reflected the administrative coldness of the era. But what happens when the 401k is just the tip of the iceberg? What happens when the divorce involves international assets, or when one spouse tries to roll their 401k into an offshore account to avoid the QDRO entirely? In the next part of this deep dive, we are moving into the dark world of asset hiding and the sophisticated digital forensics used in the late 2010s to track down missing retirement funds. We will look at the rise of the QDRO consultant and how they became the most important person in the room during a high net worth split. We will also explore the shocking case of a spouse who successfully hid $500,000 in a 401k using a series of shell companies, and how they were eventually caught. The stakes are no longer just about the math, they are about the hunt. The hunt for hidden retirement assets in the 2010s was not a simple matter of checking a bank statement. It was a high-stakes game of digital forensic hide-and-seek. To understand how someone could hide $500,000 in a 401k, we have to look at the intersection of corporate structure and ERISA law. Imagine a scenario involving a tech consultant named Gregory in 2017. Gregory was a high earner who operated through several S corporations. When his marriage began to dissolve, he didn't just stop contributing to his main 401k. Instead, he created a new secondary shell company that existed only on paper. This shell company established its own 401k plan. Gregory then channeled consulting fees into this shell company and maximized the profit-sharing contributions, effectively siphoning off $50,000 to $60,000 a year into an account his spouse, Sarah, didn't even know existed. In the 2010s, this was a sophisticated form of asset shielding. Because the 401k was under a different federal employer identification number, or FINE, a standard subpoena of Gregory's primary employer would never reveal it. Sarah's legal team had to go deeper. They didn't just look at his W-2, they had to perform a lifestyle analysis. If Gregory was earning $400,000 but only $250,000 was showing up on the tax returns he shared with Sarah, where was the rest? The historical trends of this era show that the smoking gun was often found in the corporate tax returns, specifically Form 1120-S, where deductions for pension and profit-sharing plans are listed. By cross-referencing these deductions with Gregory's known accounts, forensic accountants in 2018 were able to identify the discrepancy and trace the funds to the secret shell 401k. This leads us to the rise of the QDRO consultant as a specialized powerhouse in the late 2010s. For decades, regular family law attorneys handled these transfers, but as plans became more complex, the margin for error became a legal liability. A QDRO consultant isn't just a lawyer. They are often a blend of an actuary and a tax strategist. In 2026, we see the legacy of their work in how modern settlements are structured. During the mid-2010s, these consultants were brought in to deal with the valuation of unvested assets. Imagine if Gregory had $500,000 in a 401k, but $200,000 of that consisted of unvested employer matching contributions. In 2015, the question was, is that $200,000 marital property? The potential outcomes depended heavily on the state. Some courts ruled that since the money hadn't officially been earned yet, the spouse had no right to it. Others used the Harrison formula or similar legal precedents to grant the spouse a contingent interest. This meant Sarah would get her share only if and when Gregory stayed at the company long enough for the money to vest. The QDRO consultant's job was to draft language that accounted for this if, as, and when scenario without violating the plan administrator's strict rules. The 2010s also introduced the complication of the multi-employer plan. These are common in the trucking, construction, and entertainment industries. If you were a set designer in Los Angeles divorcing in 2014, your 401k wasn't held by a single company but by a union trust. These trusts were notoriously difficult to deal with. They often had their own internal QDRO departments that would reject any order not written on their specific proprietary forms. If a lawyer tried to use a standard template, the set designer's spouse might wait a year just to get a rejection letter. This administrative friction was often used as a stalling tactic by participants who wanted to pressure their ex-spouses into taking a smaller, immediate cash settlement instead of waiting for the retirement split. Step by step, the detection of hidden 401k assets required a multi-pronged strategy. First, the legal team had to request a credit header report. While this doesn't show account balances, it does show every financial institution that has ever run a credit check on the individual, which can reveal the existence of obscure retirement providers. Second, they had to demand the plan document itself, not just the summary plan description. The full plan document often contains the black box rules for how the plan handles QDROs and what types of alternative investments are allowed. Third, they used the Department of Labor's Form 5500 database. This is a public record where every 401k plan in the US must report its financial status. If Gregory claimed his company's plan was worth $100,000, but the Form 5500 showed $1 million in assets for a company with only 2 employees, the lie was exposed. The 2010s also saw the emergence of the loan-back scheme. A participant would take a $50,000 loan from their 401k, ostensibly for a marital purpose, but then lose the cash or put it into a private investment that they claimed went to zero. In reality, they were just moving money out of the 401k and into a friend's business or a safe deposit box. The goal was to reduce the 401k balance before the valuation date. This is where digital forensics became critical. By tracing the movement of the loan proceeds from the 401k check into the bank account, and then out to the final destination, investigators could prove that the loss was actually a fraudulent conveyance. Historical case studies from 2019 highlight the extreme measures some took, including attempting to roll 401k funds into an individual retirement account, and then attempting to move that IRA into an offshore trust. While a 401k is strictly protected by ERISA and generally cannot be moved offshore easily, once the money is rolled into an IRA, some of those ERISA protections vanish. However, the IRS and the Department of Justice became incredibly efficient at flagging large, unusual transfers to foreign jurisdictions during this time. The participant who tried this often found themselves not only losing the money in the divorce, but also facing federal investigations for tax evasion and money laundering. Another subtle but effective tactic in the 2010s was the manipulation of the investment portfolio to generate phantom losses. A participant might choose to invest their 401k in a way that hedges against the rest of their portfolio. For example, if they had a large brokerage account that was doing well, they might fill their 401k with inverse ETFs or highly speculative options that were likely to lose value. On paper, their 401k looked like it was shrinking, which reduced the amount they had to pay their spouse. But in reality, their overall net worth was stable or growing because the losses in the 401k were being offset by gains elsewhere. Proving this required a holistic view of the entire financial picture, something many divorce attorneys in the early 2010s were not trained to do. By 2026, the lessons of the Gregory and Sarah case have become part of the standard playbook. We now know that the 401k is the ultimate paper trail. Every contribution, every loan, and every investment change is logged by a third-party record keeper. You can lie to your spouse and you can even lie to your lawyer, but it is very difficult to lie to the digital ledger of a major financial institution. The hunt for assets always leaves a mark, and in the 2010s, those marks were often found in the most boring documents imaginable: the payroll stubs. If a participant's take-home pay dropped suddenly 3 months before the divorce filing, it was almost a certainty that they had increased their 401k contributions to the maximum to hide cash. But what happens when the 401k isn't hidden, but it is effectively locked away behind a wall of bad debt? What happens when a 401k is the only thing left after a bankruptcy, and the ex-spouse is trying to get their share while creditors are circling the wagons? In the next part of this deep dive, we are exploring the intersection of 401k divorce and the US Bankruptcy Code. We will look at why a 401k is often the untouchable asset that survives a total financial collapse, and the specific ways an ex-spouse can use a QDRO to jump to the front of the line of creditors. We are also going to reveal the anti-alienation secret that saved thousands of families from losing everything during the post-recession years. The shield of ERISA is about to become your best friend or your worst enemy. The anti-alienation provision of ERISA is arguably the most powerful financial shield in the American legal system, and during the post-recession landscape of the 2010s, it became the primary line of defense for families facing total economic collapse. Under Section 206(d)(1) of ERISA, it is explicitly stated that benefits provided under a retirement plan may not be assigned or alienated. This means that, in most circumstances, a 401k is off-limits to general creditors. If you owed $100,000 in credit card debt or were facing a massive medical bill, those creditors could not touch your 401k. However, the 2010s taught us there is one massive gaping exception to this rule: the Qualified Domestic Relations Order. In the world of bankruptcy and divorce, the QDRO is effectively a golden ticket. Imagine a scenario involving a man named Patrick in 2013. Patrick had lost his business during the 2008 crash and was finally filing for Chapter 7 bankruptcy. He had $400,000 in his 401k, which was exempt from his bankruptcy estate, meaning his creditors couldn't touch a penny of it. At the same time, Patrick was divorcing his wife, Cynthia. In a standard debt collection scenario, Cynthia would be just another person Patrick owed money to. But because of the way ERISA is structured, Cynthia's claim through a QDRO allowed her to penetrate that anti-alienation shield. While Patrick's credit card companies walked away with zero, Cynthia was able to secure her $200,000 share of the retirement account. This historical trend highlighted a unique hierarchy. In the 2010s, a spouse with a QDRO held a legal status far superior to almost any other creditor in the United States. However, the intersection of bankruptcy and 401k divorce in the 2010s was fraught with technical landmines regarding the timing of the filing. If Patrick had filed for bankruptcy before the divorce was finalized, the 401k remained protected. But if the divorce was finalized first and the court ordered Patrick to pay Cynthia a cash settlement instead of a QDRO-based transfer, that cash settlement was often considered a dischargeable debt in bankruptcy. This led to a strategic legal chess game. Savvy attorneys for the non-employee spouse insisted on the QDRO specifically because it created an ownership interest in the retirement plan itself, which survived the bankruptcy of the other spouse. If the attorney had settled for a simple promissory note or a cash payment plan, their client might have ended up with nothing when the bankruptcy court wiped the slate clean. Step by step, the protection of these assets during the 2010s required a very specific order of operations. First, the divorce attorney had to ensure that the 401k was explicitly identified in the divorce decree as marital property subject to a QDRO. Second, the QDRO needed to be filed with the court and served on the plan administrator as quickly as possible. In 2014, case studies began to emerge where a participant would file for bankruptcy in the small window of time between the divorce decree and the formal approval of the QDRO. This created a legal gray area. Did the spouse own the money the moment the judge signed the divorce papers, or only when the plan administrator stamped the QDRO? The potential outcomes of these cases often hinged on state law and specific bankruptcy court rulings, leading to a period of intense litigation over what was termed the vested interest of the ex-spouse. The 2010s also saw the rise of the domestic support obligation, or DSO, within bankruptcy proceedings. Under the Bankruptcy Abuse Prevention and Consumer Protection Act, DSOs were given high priority. If a portion of a 401k was being used to satisfy back-owed child support or alimony, It was virtually impossible for the participant to discharge that obligation through bankruptcy. This created a powerful tool for enforcement. If a participant refused to pay alimony but had a large 401k, the court could use a QDRO to forcibly extract those funds. In 2015, we saw several high-profile cases where 401k accounts were liquidated against the participants' will to satisfy years of unpaid support obligations, demonstrating that while ERISA protects you from a bank, it does not protect you from your family responsibilities. Imagine a situation in 2026 where we are looking back at the valuation gap that occurred during these bankruptcy divorce overlaps. In 2016, a participant might have tried to intentionally devalue their 401k by taking out a maximum loan before filing for bankruptcy, hoping to reduce the amount available to their spouse. However, bankruptcy trustees in the late 2010s became increasingly aggressive at sniffing out this kind of bad faith behavior. If the trustee determined that the loan was taken out specifically to hinder a spouse's claim, they could move to have the loan treated as a fraudulent transfer. This would not only fail to protect the money, but could also lead to the dismissal of the bankruptcy case entirely, leaving the participant exposed to all their creditors. Another critical component of the 2010s 401k landscape was the 401k rollover trap during a financial crisis. Many people who were laid off in the early part of the decade rolled their 401ks into IRAs. While this offered more investment flexibility, it also fundamentally changed their legal protection. While 401ks are protected by federal ERISA law, IRAs are largely protected by state law. In some states in 2012, like California or Florida, IRA protections were quite strong. In others, they were much weaker. If a couple rolled a 401k into an IRA and then faced a lawsuit or a bankruptcy during their divorce, they might have accidentally stripped away their federal anti-alienation shield, leaving their retirement savings vulnerable to outside creditors. This mistake cost families millions of dollars in the mid-2010s and serves as a primary case study for why the form of the retirement account matters as much as the amount. Historical trends also show that the 2010s was the decade of the QDRO malpractice surge. Because the intersection of tax law, ERISA, and bankruptcy was so complex, many generalist lawyers made errors that weren't discovered until years later. For instance, a lawyer might fail to account for the early withdrawal exception available under a QDRO. Ordinarily, if you take money out of a 401k before age 59 and a half, you pay a 10% penalty. However, Section 72T(2)(c) of the Internal Revenue Code provides an exception for distributions made to an alternate payee pursuant to a QDRO. In 2017, a case study showed that a spouse who needed immediate cash for a house down payment could have taken a distribution from the awarded 401k share without the 10% penalty, if the QDRO was drafted correctly. Because their lawyer didn't know this, the spouse waited 5 years to touch the money, missing out on the best real estate buying window of the decade. The depth of these 2010s financial autopsies reveals that the 401k was the ultimate last stand asset. It was the one thing that usually survived the loss of the house, the car, and the business. But its survival depended entirely on the precision of the legal drafting. As we move into the later stages of this masterclass, we are going to look at the endgame of the 401k divorce, the actual transfer of funds. We will explore the silent taxes that eat away at the transfer, the role of clearinghouse banks, and the specific reasons why some 401k transfers in 2018 and 2019 took over 18 months to complete. We will also examine the death of the participant clause, the most terrifying sentence in any QDRO, and how it can instantly vaporize $1 million settlement if it isn't worded correctly. If you think the legal battle ends when the judge bangs the gavel, you are about to see how the administrative process can be a whole new war. The final transfer is where the real money is made or lost, and we are going into the belly of the beast. The administrative belly of the beast is a place where a judge's order meets a corporation's spreadsheet, and in the 2010s, this is where the most significant delays in wealth transfer occurred. To understand why a 401k transfer can take 18 months, we have to look at the process of segregated accounts. Once a QDRO is approved, the plan administrator doesn't just cut a check. They must create a shadow account for the alternate payee. Imagine a woman named Jennifer in 2018. She was awarded $450,000 from her ex-husband's 401k. Even though the judge signed the papers in January, the plan administrator didn't actually move the funds until September. During those 8 months, the market fluctuated wildly. This leads us to the critical role of the clearinghouse bank and the blackout period. When a 401k is divided, The assets are often sold to cash within the participant's account before being transferred to the new account for the spouse. In the mid-2010s, this blackout period, the time when the money is sitting in cash and cannot be traded, could last anywhere from a few days to several weeks. If the market surged while Jennifer's $450,000 was sitting in a clearinghouse cash account, she missed out on those gains. Conversely, if the market crashed, her cash position protected her. Historical trends show that many litigants in 2019 were shocked to find that the administrative timing of the record keeper had a larger impact on their final balance than the legal arguments made in court. Step by step, the finalization of the transfer required navigating a series of silent taxes. The most common was the involuntary withholding error. When a 401k plan administrator processes a QDRO distribution, they are legally required to withhold 20% for federal income taxes if the money is paid directly to the alternate payee instead of being rolled into an IRA. Imagine if Jennifer needed $50,000 of her $450,000 share to buy a house. If she told the administrator to send her $50,000, they would only send her $40,000 and send $10,000 to the IRS. In 2016, a frequent case study involved spouses who didn't realize that the 20% withholding was merely a down payment on their tax bill. Depending on their total income for the year, they might still owe another 10 to 15% when they filed their returns in April. This realization often came far too late, after the house was bought and the cash was gone. Now we must address the most terrifying clause in 2010's family law, the death of the participant provision. This is the ultimate open loop in a retirement settlement. Imagine a scenario in 2015 involving a couple named Marcus and Diane. Their divorce was final, and the QDRO had been drafted but not yet served on the plan administrator. On a Tuesday night, Marcus suffers a fatal heart attack. Because the plan administrator had not received and approved the QDRO, Marcus was still technically the sole owner of the account. Under many plan documents in the 2010s, if there is no valid QDRO on file at the time of death, the entire account balance automatically goes to the named beneficiary on file, which might be Marcus's new girlfriend or his siblings. Diane's legal team would have to rush to federal court to argue for a constructive trust, but the potential outcomes were often bleak. ERISA is a heartless statute when it comes to deadlines. The 2010s were filled with cautionary tales of ex-spouses who lost millions because their lawyer waited until Friday afternoon to mail a document that should have been overnight on Monday. This gave rise to the nunc pro tunc order, a Latin term meaning now for then. Lawyers in 2017 would ask judges to backdate QDRO approvals to a time before the participant's death to try and trick the plan administrator into paying. However, plan administrators, backed by massive legal departments, often fought these orders to avoid paying out the same money twice. Furthermore, we have to look at the hidden costs of international record keeping. By the late 2010s, many U.S. corporations had outsourced their 401k administration to firms in different time zones. This created a massive communication gap. If a lawyer in Chicago was trying to fix a typo in a QDRO, they might be dealing with a customer service representative who had no understanding of U.S. state domestic relations laws. This friction resulted in what we call the QDRO limbo. Historical data suggests that in 2018, the average time to get a QDRO approved by a major plan provider was 90 to 120 days, but for outsourced plans, that time doubled. Each day of delay was a day where the participant could potentially take a loan, change an investment, or pass away, leaving the spouse in a state of constant financial anxiety. Case studies from 2019 also highlight the issue of the 401k recapture. Suppose a participant like Marcus had overcontributed to his 401k in the year of the divorce. If the plan had to return those excess contributions to comply with IRS non-discrimination testing, the account balance would drop. If the QDRO awarded Diane a flat dollar amount, Marcus bore the entire loss. If it awarded her a percentage, both suffered. This granular level of detail, accounting for excess contribution returns, was rarely included in standard divorce decrees, leading to heated post-divorce litigation over a few $1,000s that neither party actually controlled. Imagine if Marcus's 401k was invested in a company stock fund. In the 2010s, many employees held a large portion of their 401k in their own employer's stock. If the divorce was finalized while the stock was at an all-time high, but the transfer didn't happen until the company released a bad earnings report, the value could evaporate in hours. This introduced the concept of the protective trade. In 2026, we see more people demanding that their share of a 401k be moved into a stable value fund or a money market fund the moment the divorce is filed. But in 2014, most people were passive observers to their own financial destruction, watching the ticker tape and hoping the administrative paperwork would move faster than the market. The role of the record keeper cannot be understated. Companies like Hewitt, Mercer, and Alight were the invisible architects of 2010's wealth division. They held the power to freeze accounts, to demand specific wording, and to charge fees that were often deducted directly from the participant's balance. If a participant had $100,000 and the record keeper charged a $1,200 QDRO fee, the marital pot was now only $98,800. Who pays that $1,200? Does it come off the top, or does it come out of the spouse's share? In the 2010s, failure to specify who paid the administrative fees led to thousands of small claims disputes that further enriched the lawyers while depleting the retirement savings. As we move toward the final parts of this deep dive, the focus shifts from the administration to the long-term tax strategy. We are going to explore the net unrealized appreciation or NUA strategy, which was the secret weapon for anyone whose 401k was heavy on company stock. We will look at how this one specific tax trick could turn a 35% tax bill into a 15% one, and why most divorce lawyers in the 2010s had never even heard of it. We are also going to examine the fallout of the 2010s divorce on Social Security benefits, the hidden third pillar of retirement that many people forgot to negotiate until it was far too late. The 401k is only half the story. What happens to your government-guaranteed income when you split is a whole different level of complexity. The endgame is near, and the numbers are about to get even bigger. To truly understand the 2010s endgame of retirement division, we have to look at a tax strategy that remains one of the most underutilized tools in the American financial arsenal: net unrealized appreciation, or NUA. While most 401k assets are treated as ordinary income when withdrawn, meaning you could pay up to 37% or more in taxes, NUA offered a path to capital gains rates, which hovered around 15 to 20% during the 2010s. For a couple in 2017 splitting a high-value 401k that was heavy on company stock, the difference wasn't just a few $1,000s, it was a life-changing amount of liquidity. Imagine a case study involving a man named Richard, who worked for a major US energy company for 30 years. By the time he and his wife Sandra decided to divorce in 2016, his 401k was worth $2 million. Crucially, $1 million of that was held in company stock. Richard had purchased that stock over decades at an average cost basis of only $100,000. If they simply split the account and Sandra rolled her share into an IRA, she would eventually pay ordinary income tax on every dollar she withdrew. However, if they utilized the NUA strategy through a QDRO, Sandra could potentially move her share of that company stock into a regular brokerage account. Under the NUA rules of the 2010s, Sandra would only pay ordinary income tax on the cost basis, the original $100,000, while the $900,000 in growth would be taxed at the much lower long-term capital gains rate when she sold it. Historical trends show that most divorce attorneys in 2016 were completely unaware of this IRC Section 402(4) provision. They would simply check the box for a standard rollover, effectively costing their clients hundreds of thousands of dollars in unnecessary tax leakage. This strategy required a precise sequence of events. The distribution had to be a lump sum, it had to be triggered by a qualifying event like the QDRO, and the stock had to be moved in kind. One small administrative error, like the record keeper selling the stock to cash before the transfer, would vaporize the NUA eligibility forever. While the NUA was the secret weapon for the wealthy, the broader American public was grappling with a different pillar of retirement: Social Security. In the 2010s, a massive misconception persisted that you lost your right to your spouse's Social Security benefits upon divorce. This resulted in countless lopsided negotiations where one spouse fought tooth and nail for an extra $50,000 from a 401k while unknowingly walking away from a benefit worth 10 times that over a lifetime. Consider a scenario involving a woman named Barbara in 2014. Barbara had been a stay-at-home mother for most of her 22-year marriage to James, a high-earning executive. Under U.S. law, if you were married for at least 10 years and have been divorced for at least 2 years, you are entitled to claim a divorced spouse benefit. This allows Barbara to receive up to 50% of James's full retirement age benefit amount, provided she hasn't remarried. The kicker? It doesn't take a single penny away from James, and he doesn't even have to know she is claiming it. In the 2010s, this was the ultimate invisible asset. Historical trends from the mid-2010s show that couples would often use 401k balances to offset what they perceived as a loss of Social Security. A husband might say, "I will give you 60% of the 401k if you waive your right to my Social Security." But in the United States, you cannot legally waive your right to federal Social Security benefits in a divorce decree. Such a clause is generally unenforceable. Barbara could sign that paper, take the extra 401k money, and still show up at the Social Security office at age 67 to claim her share of James's record. This created a double recovery scenario that left many high-earning ex-husbands feeling financially ambushed years after the 401k was settled. Step by step, the 2010s deep dive into Social Security required a 3-point check. First, the 10-year marriage mark. If a couple divorced at 9 years and 11 months, the lower-earning spouse lost the benefit entirely. We saw case studies in 2015 where attorneys purposely delayed or accelerated a divorce filing by a few weeks to hit or miss that 10-year window. Second, the remarriage rule. If Barbara remarried before age 60, she lost the right to James's benefit. If she waited until 61, she kept it. Third, the death benefit. As a divorced widow, Barbara could actually receive 100% of James's benefit if he passed away first. In the 2010s, the actuarial value of these survivor benefits was often greater than the entire 401k balance, yet they were rarely discussed in mediation. The complexity of the 2010s also introduced the Social Security file and suspend strategy, which was eventually curtailed by the Bipartisan Budget Act of 2015. Before this change, a savvy divorced person could claim a spousal benefit while letting their own retirement benefit grow at 8% per year. This was a sophisticated way to maximize the total liquid intake from the government, but it required the 401k to be used as a bridge. You would spend the 401k assets from age 62 to 70 to live, while your Social Security benefit reached its maximum possible value. This coordination of private 401k assets and public Social Security was the hallmark of a masterclass retirement plan in 2018. However, the endgame was often marred by the 401k loan recapture trap. We've discussed loans before, but the 2010s introduced a specific administrative cruelty. If a participant was fired or quit during the divorce, the 401k loan was often due in full within 60 to 90 days. If they couldn't pay it, the loan was foreclosed. In 2019, new tax laws extended this deadline to the tax filing date, but for most of the decade, the window was tiny. Imagine if James lost his job while the QDRO was being processed. The $50,000 loan he took for the divorce lawyers was suddenly a taxable distribution. This would reduce the total account balance right before the transfer to Barbara. If the QDRO awarded her a fixed dollar amount of $500,000, and the account dropped to $450,000 due to the loan foreclosure and taxes, the plan administrator could not fulfill the order. The entire legal process would grind to a halt, leading to a new round of lawsuits over who was responsible for the lost funds. This era proved that the 401k was the engine, but tax and Social Security laws were the tracks. If the tracks were misaligned, the engine would derail no matter how much money was inside. In 2026, looking back at these historical trends, we see that the most successful splits were those that treated the 401k not as an isolated bank account, but as one piece of a four-dimensional puzzle involving capital gains, ordinary income, federal benefits, and survivor rights. But as we prepare for the final chapter of this deep dive, there is one last area where the 2010s 401k landscape became truly bizarre. It is the world of the non-spouse alternate payee, specifically children. While 99% of QDROs are for ex-spouses, they can also be used to pay child support. This opens up a world of aggressive collection tactics that most people find shocking. We are going to look at the nuclear option of 401k division, using a child support QDRO to drain an account entirely, bypassing all the normal protections of ERISA. We will also summarize the top 5 mistakes of the decade that you must avoid to ensure your retirement isn't just a collection of legal fees. The final part of the masterclass is about the legacy you leave behind and the final audit of your life's work. The 401k story is about to reach its ultimate conclusion. The nuclear option of 401k division in the 2010s was a maneuver that many participants never saw coming until their account balance hit zero. While most people associate a QDRO with a 50-50 split between spouses, ERISA law actually allows for a much more aggressive application: the collection of child support and alimony arrears. In the mid-2010s, if a participant had spent years evading support payments, the custodial parent's attorney could secure a QDRO that functioned less like a property settlement and more like a high-velocity vacuum. Unlike a standard property division where you might split the future growth, a support QDRO can be drafted to demand an immediate lump sum payment of the total debt owed, plus interest, directly from the 401k. Imagine a case study involving a man named Derek in 2018. Derek had moved between states and worked various contract jobs to avoid wage garnishments for 10 years of unpaid child support. He had, however, managed to accumulate $150,000 in a 401k at a new firm. When his ex-wife, Samantha, discovered the account, her legal team didn't just ask for a portion of the retirement. They secured a QDRO for the full $120,000 of arrears he owed. Because this was a support-related QDRO, the plan administrator was legally required to prioritize it. Derek watched as 80% of his life savings vanished in a single administrative transaction. In the 2010s, this was the ultimate reality check for those who thought retirement accounts were an untouchable vault for bad debtors. This decade of financial warfare also left behind a definitive list of historical trends regarding the most common and most expensive mistakes. As we stand here in 2026 looking back, the 5 catastrophic errors of the 2010s have become the foundational lessons for modern financial planning. The first was the failure to account for the tax-deferred nature of the asset. We saw thousands of cases where a spouse took $200,000 in 401k cash while the other took $200,000 in home equity. By the time the taxes were paid, the spouse with the 401k actually had 30% less purchasing power. This lack of tax adjustment is perhaps the greatest quiet wealth transfer of the century. The second mistake was the oversight of the post-separation contribution. In the 2010s, it often took 2 to 3 years to finalize a divorce. If a participant continued to contribute $19,000 a year to their 401k during the litigation, that money was often considered separate property. However, if the QDRO was written to give the spouse 50% of the account as of the date of the transfer, the spouse was accidentally gifted half of the participant's post-separation labor. Forensic accountants in 2019 spent countless hours backing out these contributions to ensure that only the marital portion was divided. Third was the mishandling of the 401k loan. As we've explored, a loan is a debt to oneself, but in a divorce it is a poison pill. Historical trends show that many spouses agreed to split the account net of the loan, only to realize later that the participant was essentially getting to keep the $50,000 they borrowed, while the spouse took a 50% hit on the remaining balance. The proper way to handle this in the 2010s was to treat the loan as an advance on the participant's share, but this required a level of mathematical literacy that was often missing from the courtroom. The fourth error involves the missing beneficiary update. Even if you won the battle and kept your 401k, if you didn't file a new beneficiary form with your HR department the day the divorce was final, your ex-spouse remained the legal heir in the eyes of federal law. In 2026, we still see probate cases being litigated over 401k accounts from 2015 because someone forgot to spend 5 minutes on an HR portal. Federal law does not care about your intent. It only cares about the name on the form. Finally, the fifth and perhaps most subtle mistake was the failure to secure the gains and losses. If a spouse was awarded $100,000 in 2013, but the transfer didn't happen until 2014, that $100,000 should have been earning interest. Without specific language in the QDRO granting the spouse the earnings and losses on their share, the participant got to keep all the market growth on the spouse's money during the administrative delay. In a bull market like the 2010s, this was a massive windfall for the account owner and a devastating loss for the recipient. Step by step, the 2010s was the decade that proved retirement is not just a savings goal. It is a legal status. It was the era when the phrase QDRO proof was thoroughly debunked. Whether it was the IRS matching 1099-R forms with precision, or state agencies using 401k accounts to satisfy decades of debt, the walls around these accounts became semi-permeable. The potential outcomes for those who approached this with a casual attitude were almost always negative. Those who succeeded were those who treated the 401k as a live grenade, something to be handled with extreme care, professional guidance, and an obsession with technical detail. The legacy of the 2010s 401k divorce is one of hard-earned financial wisdom. It taught a generation of Americans that their largest asset was also their most vulnerable legal document. It emphasized that a divorce is not just the end of a relationship. It is the forced liquidation and restructuring of a decades-long investment firm. If you didn't understand the tax code, the ERISA statutes, and the administrative quirks of your specific plan provider, you weren't just getting divorced, you were being audited by your own past. As we conclude this deep dive, we have covered the mechanisms of the QDRO, the traps of the 401k loan, the shield of the anti-alienation provision, and the surgical precision of the NUA strategy. We have seen how the government can be both a protector and a predator in the realm of retirement assets. We have analyzed the digital footprints left by those who tried to hide wealth and the forensic tools used to bring it back into the light. The 2010s was the decade where the 401k grew up, and with that maturity came a level of complexity that changed the American legal system forever. But while the 2010s gave us the rules for the 401k, a new frontier is emerging in the mid-2020s. The assets are no longer just in dollars and mutual funds. We are now seeing the first wave of divorces involving tokenized retirement assets, decentralized finance accounts held within self-directed IRAs, and the complex valuation of AI-driven intellectual property held in corporate retirement vehicles. The rules of the 2010s are the foundation, but the game is changing once again. If you found this deep dive valuable, prepare yourself for the next masterclass. We are moving from the liquidation of the past to the protection of the future. In our next series, we are going to explore the shadow world of offshore asset protection and the new 2026 digital privacy laws that are making 401k discovery almost impossible for the unprepared. You think you know how to track money? You haven't seen anything yet. The next evolution of financial warfare is about to begin.